Hearing the appeal Responsible Development for Abaco RDA Limited against the Honourable Perry Christie and others.
Good morning, my lords.
Yes, Mr. Clayton.
My lords and lady, I appear together with Mr. Frederick Smith, King's Counsel, Ruth Jordan, Rowan Pennington Benton, Thomas Elliott, Roderick Dawson Malone. The government is represented by Mr. Aidan Casey, King's Counsel, and the developers are represented by Peter Knox, King's Counsel, Oscar Johnson's King's Counsel, Robert Strang, and Tara Archer, Glasgow. Now, two things before I start. First, I hope you received the speaking note that we sent.
Yes, we did. Thank you.
Thank you very much. Secondly, can I apologize in advance for the fact that I'm afraid I have a very heavy cold. So if at times it intrudes, can I just say I'm sorry about that? Well, can I begin then? My lords, as the speaking note says, we've significantly narrowed the issues with the exchange of cases, and we begin by summarizing the position in relation to two questions posed by the registry on the 28th of October. Can the appellant rely on arguments before the board not advanced before the Court of Appeal? And then was the Court of Appeal wrong to uphold or remake the security for costs order? On the first issue, the constitutional right of access to the court, we make effectively three submissions. The first is, which I'll develop later, this is simply not a new point. The second is that in relation to the Article 20(8).
Sorry, when you say not a new point, what's not a new point?
The constitutional issue.
Right. Sorry, and the constitutional issue is...
It's Article 20, whether this breaches the constitutional right of access to the court.
Right.
Whether
but why does that matter in this case? I thought, or one way or another, either under Article 15 or Article 20, it's accepted that there is a constitutional right of access to the court.
I accept that too, but the only reason I'm dealing with this at all is those were the questions posed. So I thought perhaps I'm not going to disagree with that at all, if I may. It is accepted. In which case, I think I can cut through most of the submissions I make in relation to, get to the bottom of page 2 of the speaking note, then I'll turn to the Bolton submissions, which I summarize again. We say it's not a new point for reasons I'll develop later. There was copious references to what were essentially Bolton principles below, and if necessary, for the reasons enumerated by Lord Newburger and Oceana Heights, we would submit that this would be a point which the board should address in any event. Turning to the order of batting, you'll see the way we've set it out, and I'd like to begin, if I may, by referring to the judgments below and to confirm that we accept before the board that it's open for the court below to have ordered security for trust under the Companies Act under Section 285. But if one refers to the judgment below, we make, well, just perhaps we should turn it up quickly. It's at page 49. And I'll deal with it quite quickly.
Sorry, which document are you taking us to?
49?
Yes, but which document?
Sorry, this is the judgment of the
Court of Appeal or the judge?
Supreme Court.
Thank you.
And then I'll go to the Court of Appeal judgment.
Yes, thank you.
429 of the electronic bundle.
429 of the electronic. All the references I'm going to give are to the electric bundle references, and they're the same. There should have been. We double-checked the references in the speaking notes, and they should all be correct, as I understand it. And I want to simply make three brief points about it. Firstly, of course, as your lordships will know, the Supreme Court doesn't deal at all with whether it's appropriate to grant security for costs. It just deals with quantum. And then, if I could invite you, well, you probably already read, as 6. Paragraph 6 is the reference to the disposition and the order made, which was 100,000 for the government, 150 for the developer. And as we contend, this is the top of page 4 of the speaking note, no reasons specific to the facts of the case were given for those conclusions. None at all. And if I could then next take you to the Court of Appeal judgment, and which is to be found at EB 786, but I'm going to go straight to the quantum section, which is at 804, electronic bundle 804. Obviously you'll have read this before, but in our submission, it's important to read this Court of Appeal judgment in the context of the failure of the court below to make any fact-specific decisions. Because this case, this judgment too, is completely empty of any fact-specific findings justifying the conclusions reached in respect of this case. And as we say, there are no reasons specific to the case for ascertaining quantum beyond affirming the judgment below. And we say 8.2, forgive me, of the speaking note, that this is particularly odd in view of a discussion that took place at the Court of Appeal when Justice of Appeal Sir Michael Barnett pointed out to the government's counsel, Mr. Klein, that in this case it's odd, given that the government had filed a bill of costs and given that it was the government that was the principal respondent to the application because the challenges were made to the government decisions, that the judge awarded the developer 150,000, which is 50,000 more than the government. This seemed a bit odd, and he describes that later on in this is all from the transcript, as irrational. Now, it's very odd, given that discussion with counsel, that there isn't...
Well, he says that at paragraph 69, in effect. It would seem that the amount cost to the developer should not be more than the cost for the government.
Yes, he does say that, but what he doesn't explain is why what he does is make comparisons with other cases.
Well, then he said it's because it was more in another case, it's fine to have it more in this case.
Yeah, well, with respect, again, that lacks any fact-specific explanation at all. I mean, we'll look at it in more detail, obviously, later on, but I accept that he says that. The other point I'd also make...
Sorry, just before you move on, had the developer filed a bill of costs?
No. The courts never saw a draft bill of costs from the developers at any stage in the courts below.
I think they provided one, didn't they? But it was excluded because it was too late or something.
Yeah. That's correct. But I also want to point to paragraph 70 of the Court of Appeal judgment, where Sir Michael draws attention to Lord Hoffman's remarks in the Irish RDA case about the need for an intervention to actually add value. That, in our submission, is significant in the context of this case, because as I shall demonstrate shortly, at no stage do developers indicate they're adding any value to the case. And indeed, they never file any evidence relevant to the case itself. The next point I want to move on to...
But I mean, just that's addressing whether there should be an intervention as distinct from the costs associated with an intervention.
Yeah, I
mean, intervention in planning cases by the developer is entirely normal in my experience.
My lords, as in mine. I'm not saying that it's anything other than that. What I am saying, however, is that an application for security for costs is, in our submission, a novel proposition which this court will have to wrestle with in due course. And all I'm saying is that I don't want to get stuck on a non-point, but is that it's significant that reference is made to RE, because you wouldn't say that unless you had some question in your mind about what was the point of the developers being there. It also cuts against the idea that they should have got security for 150,000, we would say.
Also, isn't Lord Hoffman talking about interventions in, as it was then, the House of Lords, i.e. in relation to the argument? Well, that's not the same as a party which has an interest in a development being joined as an interested party at first instance, is it?
No, but with respect, I entirely accept that. But this case is not about whether they intervened. They were served as interveners. This case is about whether they were entitled to get security for costs, which is a very novel development.
Your point is it that the fact that the Court of Appeal cited this passage, even if it was inapt, but it shows that they had some concern as to whether the interveners were actually going to add anything to this.
My lord, that's precisely my point. If I've expressed it poorly, I apologise, but that's exactly the point I've been endeavouring to make. The next point I wanted to come to, paragraph 9 of the speaking note, is that it's contended by Mr. Casey that it's well established that security for costs may be ordered in judicial review proceedings. That I don't dispute, particularly in planning cases. But what is illuminating are the cases he relies on, which are before the board, and the costs orders that were made ultimately. What I'm going to say is that the cost orders for security for costs in this case are completely out of line, and indeed, on the facts of this case, very difficult to defend. And it's helpful just to see that. I should also have said, perhaps this was obvious, but the Bahamian dollar and the US dollar are roughly par. So you're talking of a significant amount of money, 250,000 US.
You can't really just look at the absolute sums. We don't really know whether this is out of line without knowing what proportion of the estimated costs these people were going to incur. I mean, 15,000, yes, it's much less than 100,000, but we don't know what proportion that was.
Well, I'm going to demonstrate, I entirely accept that. I'm going to demonstrate that this is an incredibly simple case. That's the next point I'm going to demonstrate, and which it is. And it is simply striking, to say the least, that the security is so high. If I can move on to that point, please. What's said at top of page 5, paragraph 10, is another criticism advanced by Mr. Casey, is that the judicial review challenge is unduly wide and complex. And we would say, and do say, that that characterization is entirely misplaced. If we turn to the grounds of challenge, which you'll find at page 31 of the bundle. If you have that. It's set out in 2 paragraphs, which begin at 38 and go over the page to 39. Let's ask you to look at that. And then in terms of relief, again, this is really quite straightforward. If you could turn to page 11 of the electronic bundle. You will see at 11 and 12, the relief sought: a declaration, an order of prohibition, an order for certiorari. So, to describe this case as complicated, for reasons which I'm now going to explain in slightly more detail, is surprising. Now, I next want to turn to...
Sorry, just in relation to the grant of the permit, can we just check on the position in relation to the required permits? They haven't been issued yet?
That's our understanding, yeah.
Right.
Then I next turn to the next paragraph of the speaking note, the criticism about the application being made, this is for security, being made just 5 days trial, does not withstand scrutiny, says Mr. Casey. I'm afraid that really did tempt one to look at it in some detail. And with respect, that is again incorrect. Can I just take you through this table, which took more time to prepare than may be apparent from its slight length? The judicial review application was filed on the 22nd of March. There was a contested leave application before the trial, before the learned judge, on the 24th of June. And as my Lord...
Does it really matter, Mr. Clayton? I mean, at this stage?
Yes.
Why?
Because I'm going to demonstrate that the case was ready for trial, that it was an incredibly simple case, and that the quantum of 250,000, leaving aside the enormous criticisms made on the way through, just can't be.
I see. So it's not so much the fact that the security application should have been made earlier, but you're saying it was what we get out of this is it was an easy, simple case. Is that?
Yeah, that's where we end up.
What prejudice did you suffer as a result of the application being made late, as you say?
Well,
you had plenty of time to. You only had to serve your evidence on the security for costs application by January, and you served your evidence towards the end of January. No permits were issued, and no development took place in the interim.
yes.
So why does it matter? Is it a point about costs in the past and costs in the future, or what is the point?
The point about this case is this, and the key order is actually made on the 25th of November. I mean, I would invite you, this exercise wasn't done for a totally purposeless reason. On the 25th of November, the government filed 2 affidavits for trial. One by...
I'm so sorry, just following up my lady's question, I'm not quite sure that you've explained to us exactly why this is relevant. Are you making some point that all the costs will have been sunk already because everyone was preparing for trial, therefore security ought not to be ordered for costs going into the future?
What? No, I'm making a point about quantum.
I thought you said in answer to my question that why you were relying on this was not now at this stage to say the application was made too late or anything like that, but that this was you were going to show how little evidence was involved in this case.
That's what I was trying to get to, my Lord, yes. But what I wanted to, just before I took you to the evidence, to point out that that the summons was issued on the government summons on the 23rd of November, as it says in the table, and on the 25th, the government filed its affidavits 2 days late, which of course preempted the trial, which had been set months before, and properly set in accordance with the rules and with the government's foreknowledge. 2 affidavits, one 6 pages without no exhibits, one of 5 pages with basically newspaper clippings. And on the 28th of November, the trial was adjourned to the 23rd and 24th of February 2017 for 2 days. That's relevant because the trial date was reduced from 3 days to 2 days, again reflecting the simplicity of this case. Turning the page 6 of the speaking note, on the 13th of December, the developers made their application for security and also to intervene. And the point I want to make, the last line of the box at 13th of December, as at no stage did they apply to serve any evidence in respect of the trial listed for February.
This is the developers.
This is the developers. So, and nor did, as it happens, the government say they wanted to file more evidence. Either they didn't apply to add to the evidence. So where we get to is we have a trial scheduled for 2 days on the 23rd of February 2017, where both respondents, or all the respondents, the government and the developers, have contented themselves with saying, well, if this case goes ahead on the 23rd of November, then, 23rd of February, I'm so sorry. 23rd of February, then those two affidavits are the trial affidavits. And I really make those points in speaking note at 13.1 to 3. At 3, we refer to the figures being high in any event, and refer to, but I'm not going to take you to the detail of criticisms which are cross-referred to, but there are numerous criticisms of quantum, but also specifically at 13C, that the defendant chose not to adduce any additional evidence for the trial listed at February. That was the position that pertained. They were simply going to rely on what they had. And I therefore want to emphasize the point which we set out at the subpoint 4 at page 7. The slight volume of evidence demonstrates that the complexity of the appellant's claim should not be overstated. And I want to make good that by turning, if I may, to the main evidence which the government relied on, which you will find at electronic bundle 1183. Sorry.
Seems to be a transcript.
Is it? No, the affidavit of Philip Weech.
No. It's a wrong reference.
You maybe want 1883, do you?
I do. I'm sorry, I do tend to transpose. It's very irritating. It's my fault. Thank you.
So it's
1883. Sorry, it's my fault.
Affidavit of Philip Weech.
Yeah, and he refers to the other affidavit. So he's the director of this body called the Bahamas Environment, Science and Technology Commission. That's paragraph 1. Paragraph 4, he refers to and has read the Jacqueline Estevez affidavit, and he cross-refers to that. 5, he describes the role of the commission. If you look at 1885, he describes the analysis that the environmental impact assessment went through, which was received on the 30th of January 2015. And then I think I can go to the top of the next page, 1886. He says, it's not correct to say that the Best Commission ignored the request. That was for the EIA.
I'm so sorry. Where are you reading from?
1886.
Yes, and where on the page?
Top of page.
All right. Yes.
However, it's not correct to say that the Best Commission ignored the request.
This was a request of the residents to be provided with the EIA, is that
correct?
right?
Yep. Sorry, that's right, and I did say that a moment ago. Anyways, the delays is explained by the fact that they were doing their best not to release this information to the public. In fact, to ensure objectivity and impartiality, and that it wouldn't be influenced by the observation of views from any interest, that was the view that they took. Now, that does raise questions about whether the first gunning requirement, I'm going to come to shortly in a minute, is being addressed, which is you're supposed to consult when something is in a formative stage. And then turning to what steps were taken to consult, 13, it's important to state that it was the Commission's policy to post on its website EIAs, etc., for review prior to public consultation. And the EIA was made publicly available for inspection within the relevant district, and that's 14, and posted on the website. Now, certainly, that seems to be the extent of the attempt to communicate the proposals to the local locality, according to this. Then turning to 1887, please.
Yes.
1887, paragraph 17. I wish to add that in my experience and based on the best international practices, we adhere to with respect to public consultation and development projects. My understanding of the critical element of this process is, 1, information should be in the public domain and available. 2, time should be allowed for review and feedback. And 3, this feedback should inform the decision-making process. Now, 2 points I want to make about that. First, we're not told what this international practice is. I don't know where it comes from. But secondly, and more importantly...
So, why does that matter? I mean, these sound like quite sensible general principles. In fact, they seem quite similar to the gunning principles.
Well, I'm about to show you and say that they're not really.
All right. Yeah. Okay.
This is really just a matter of argument anyway. I don't really see that this evidence, that paragraph of the evidence is...
Was he an expert?
He's not an expert, is he? I mean, he's just giving his opinion, probably inadmissible anyway.
I understand that, but I'm just simply making this point, which in our submission is of some significance in the context that the orders made of the scale of security, is there could be a debate about this. I'm not suggesting there won't be. But it's not going to be a very long debate, and ultimately the question that the board will have to consider is whether the order for 250,000 quantum is a defensible order in the circumstances of the case. That's our principal point.
I mean, if your challenge is to consultation, then somebody needs to have set out what meetings there were, who attended the meetings, how they were publicised, what was available. Now, is that Mr. Weech's evidence, or is that someone else's? Is there a dispute about that?
There is very little dispute. This was a case which the child judge listed for 2 days. And I accept entirely the point made that there are matters that can be debated. But what I'm trying to indicate is the parameters of the debate are relatively limited. And this is not a case that's going to take a long time. It doesn't involve any complicated issues of law, nor does it involve any complicated issues of fact.
Well, 2 days seems rather generous on your description so far.
Yeah, well, we would say so, yes. But this was the material that was before the court, and this was the only material that was before the court. This and the other affidavit, which I'm not going to take you to because of time.
But just to assist us for our note,
yes.
Where do we find the material that my lady referred to in the evidence on both sides?
You will find the evidence on the respondent side is in some important claimant side. On the respondent side, we have, the evidence another witness statement, which is to be found at electronic bundle 1676, which is the witness evidence of, forgive me, it's a local authority person. And can I...
Is that, so this looks like the affidavit that was cross-referred to by...
That's right, that's why I didn't take you to it. It's very short.
Right.
Anyway.
So that's on the respondents' side.
Sorry. Yeah.
Presumably there's an affidavit on the applicant's
There is.
side setting out
There is. Well, the actual...
Can you just give us the where we find it in the bundles, just for our
It's
notes?
1376, David Pitcairn's evidence.
So am I right in thinking, if we look at, in our own time, at these two affidavits, we will see the parameters of the dispute that had opened up between the parties on the judicial review application?
Exactly.
All right, thank you.
So I'm sorry I made a...
Sorry, what was the page number for Mr. Pitcairn's affidavit?
1376.
And did the developers didn't put in any evidence?
No.
On the substantive claim?
Not on the substantive thing.
Thank you.
And just to sketch out a number of implications of this, the only legal issue is, the first legal issue is whether it satisfies the gunning principles. Can I just briefly take you to that, please? Which you will find...
The what, the consultation?
Principles, yeah. They're found in a case called Mosley, which the Supreme Court decided...
I'm just a little bit lost why you're taking us to these without showing us the evidence.
Well, I'm perfectly happy.
I don't want to take you out of your way, but I just want to understand why you're going to show us the gunning principles, but you're not going to show us the evidence.
Well, let's go to 1376. I'm perfectly happy to do that. 1376 is the claimant's evidence. 1389. Sorry. 1389 contains the relevant passages.
I don't want to push you into this.
No,
it's really a question of whether you think it will assist us to understand the case.
I think it will.
All right, we'll do it then. Where do you want to take us?
Okay. Paragraph 38, sorry, 1389, paragraph 38. This is where there's discussion about meetings, and just for the purposes of the note, those facts end at 1392. So it's paragraphs 39 through to 47. So that is the appellant's evidence on what actually the factual consultation.
So do you want us to take a couple of minutes just to read that
Yes, please
ourselves?
do. Yeah, sure.
All right.
Sorry.
Whether we have that short note of the meeting that he refers to in paragraph 39.
I'm sure you do you know what the note is? I don't? Just, no, I'm sorry. No, all right, okay. Mr. Smith makes a slightly different point, which I think was in relation to a specific question from Lord Sales, was what was the evidence that the learned judge referred to in her judgment? She didn't refer to any evidence at all, of course. But what I'm looking at is what the evidence in fact was, which was considered by the Court of Appeal in the context of whether there were merits.
And I think my lady asked you for the reference to the note.
Yeah, and I'm just,
Oh, right.
I'll pass that up when I get it, if I may. Well, sorry, if you've had the opportunity of reading those passages, I mean, there may be, and we will give you a definitive answer after the short adjournment, but if there are any particular documents which are key, we will give them. But my submission simply is this, this is not a particularly difficult case.
Right. And can I just check, in addition to the affidavit, was there a pleading?
Yes, there is a pleading, and that's the leave application. So can I just put that back?
I don't want to take up a lot of time reading repetitive material, but it would be helpful if you could just give us a note to that.
No, well, I can find you that. Just give me a sec. 9. It's page 9 of the bundle. Is the page which deals with the. It's 9 paragraph. Well, that sets out the parties. The parties are described from pages 14 to 18. The development proposed from 18 to 20. And then a chronology of relevant facts appears from 23 to 25. So again, really quite compressed.
And then, so we've looked at Mr. Pitcairn's evidence. Are you going to show us also Ms. Estevez?
I'm happy to do that, but before I do, can I give an answer to the question I was asked about the meeting note? That's at electronic bundle 1487. Thank you. Now, sorry, if I can just be given.
Oh, that's a different meeting.
No, I don't want that. Oh dear.
So does it basically come to this, that the case is that there was only one meeting, that the EIA was not disclosed till after the meeting, and when it was disclosed, it showed a different, materially different project from that which was described at the meeting?
Yeah. With respect, yes. And what our case very simply is, it's not a hard case. It's a short case. It has been swept away by the developments on security for costs. In terms of the potential issues, it's worth saying this. There are factual issues which need to be investigated with a view to seeing whether the gunning principles have been satisfied. And so I would like to, if I can, take you to Moseley, which is at EB 3070.
Right, so this is going into the authorities. Before we do that, were there in fact factual issues? Was there a disagreement about the factual picture that my Lord described?
Not really very much. I mean, Ms.
Estevez does mention more meetings and more things, but it may be that wasn't crucial to your case.
Yeah.
So you're taking us to, what was it, 3170? It seems to be in the middle of still.
So I've just been given a reference to another meeting, which may be in the meeting that Lord Sales was talking of, which is at 1491, which was the next meeting following the one of 1487. Now, Mosley was the case where the Supreme Court confirmed the gunning principles. It's to be found at 3061. And I'm going to just take you straight to the analysis of the law from Lord Wilson. I would invite you in due course to read from 3070 paragraph 23 to 3072 paragraph 28, where he sets out the law. But for these purposes, I only need to look at one section, which is the gunning principles themselves, which are very long established. This is at paragraph 25 at 3071. And they're quoted, actually, it would seem, from the submissions made by made by Stephen Sedley, Queen's Counsel at that time, in front of Mr. Justice Hodgson and Gunning. And its consultation must be made at a time when the proposal is still at a formative stage. Second, the proposer must give sufficient reasons for any proposal to permit of intelligent consideration and response. Third, that the adequate time must be given for consideration and response. And fourthly, the product of the consultation must be conscientiously taken into consideration. In practice, the second criterion is one of particular importance, and it's obviously important for consultees in making informed representations to the decision maker to be adequately informed about the proposals. Now, those four issues would need to be canvassed at this two-day trial. And assuming, and I'm not making submissions about this, assuming that it was decided that there was non-compliance with gunning, that would still leave another further issue to be considered, which is the failure to comply with the gunning principles so unfair as to make it unlawful? So there's a fifth legal question. It's not addressed in this case, but it is that would arise where there's a breach of gunning principles, and that's well-established law in England and therefore in the Bahamas.
Sorry, is that really right? I thought that the gunning principles, in effect, reflected the principle of fairness.
They do, but there has been quite a lot of debate in the authorities. The most recent case is a case in the Court of Appeal in 2020, the English Court of Appeal. But basically, assuming that there is a breach of the gunning principles, it's still necessary for the claimant to show that the failure to comply with the principle is so unfair that it renders the decision unlawful. In other words, it's not a mechanical process. It's not just saying, well, you've breached the criterion, I, the claimant, therefore win. There's a fifth question that needs to be addressed.
All right, thank you.
I mean, part of the problem here is that no decision's actually been taken, has it?
Well,
I mean, they haven't granted a permit or approved the development. Or have they? What's the decision that's challenged?
As I understand it, that is actually a matter of some uncertainty from our side.
I thought I asked you that question. You said no permits had been issued.
Our assumption is that the position is...
Well, maybe the government will be in a better position
sure.
when it's there.
But just so I've understood your position, are you saying we don't know? So even though you told me, no, it hasn't been granted.
I was repeating, it's my fault. I was repeating what I was told, but I think that the proper answer is what we have assumed, because, and this has been a feature of this litigation, is there's been a failure to answer correspondence of any kind.
All right.
But there was an exchange which is referred to in the papers in one of the courts below, where counsel for the developer was asked whether the development had proceeded because the injunction effectively had been lifted, and he replied no, because the permits are subject to challenge.
But that would assume
that they had been granted.
That they'd been granted.
Yeah, well, that was what apparently, if my recollection is correct, that's what counsel for the developers said.
Well, that's, if I may so, probably is the best.
Well, I don't think so. I think we probably should at some stage.
Well, I'm no doubt Mr. Casey can cast light where I.
I read that as meaning that no permits have been issued because of this challenge going on. But, well, somebody should.
Unless they have the permits, they couldn't proceed, presumably.
I don't know.
Well, can I just... Anyway, I'm sorry about the level of confusion, but the difficulty is, and this is a feature, I'm afraid, of the environmental litigation in the Bahamas, is that it's very difficult to get clear answers when letters are sent. So,
well, Mr. Casey's heard us talking about this. I'm sure at the appropriate point he can clarify that.
Okay. But all I have been trying to convey, albeit at excessive length, is that on the face of it, this is a relatively simple case which would have been disposed of in 2 days. And one does therefore ask, how do you get to $250,000?
Do you say that $100,000 for the government parties was excessive?
Yes. And I've cross-referred in the speaking note, but there are numerous complaints. For example, this is just from memory, there's a flat rate charged in respect of each of the respondents, I think for something like $4,000 each. And on the draft...
That may just be the way it's split up for budgetary purposes. I mean, it doesn't... I mean, one would have to look at the global figure, surely.
Well, I think I ought to make this point at the very least. If you look at the draft bill and you look at the two affidavits, you ask yourself the question, well, how do these fit?
Yes.
They don't.
I mean, I'm not sure by what standards we approach that sort of question, where we have no experience of litigation in the Bahamas. We don't know what...
No, I understand that.
What the level of costs and so on.
I understand that, and I fully appreciate my Lord's point. I simply make this point, though. If you look at the actual draft bill itself and then the two affidavits, it's quite puzzling.
I mean, I see from one of the cases you cite, which is the Haringey, the We Love Haringey case, that the local authority there sought security for costs of £100,000.
Yeah.
And the judge ordered security in the amount of £60,000.
Yeah.
Which may not be wholly out of line with the figures we're talking about here.
I think it is. This is 100 to the government, 150.
Well, I was actually asking about the government.
Oh, just about the government. Well, yes. I mean, I can't do better than make the point that you're looking at two affidavits and you have to take a view on how that stacks up against the draft bill of costs. So
it was. I mean, it was your choice to bring this claim against 8 different government bodies.
Yeah.
Now, are they all being represented? How many sets of lawyers are there for those 8 different?
They're all being represented by one person. Yeah, well, we'll do. Yeah, we deal with some of these issues in the annex to the speaking note, but the difficulty, as I say, is that in the Bahamas there's a slight problem about worrying over debates about non-joinder. So you try and anticipate what the case is because you haven't been told, and then you join people in. So far as there are issues about it in this case, there are complaints made by the government about strikeout, but that would be addressed at trial. So it doesn't...
Well, we've got so far, as you say, this is an incredibly simple case. There's a few pages of affidavits, and you just have to measure those up against the question whether there's been a fair consultation or not. And so... Yeah.
And that takes...
Where do we go from there?
Well, I think where it takes us to is the first ground of appeal that I want to deal with at greater length. which is...
Sorry, just on the factual material, just that we've got it in our notes. The bill of costs is where in the bundle and the two affidavits. I don't want to be taken to them. I just want to make sure I've got the correct note.
Just give me a minute. Can you give me the bill? Then there's also, you'll want to read our criticism too.
Well, look, if you don't have the references readily to hand...
No, I don't. They're in the
fed through
note.
to us at some... Well, they may be in the note, but I was asking for assistance. But they can be fed to us at some appropriate point by...
Yeah, but 1743
is the bill, is that right?
Yes, the draft.
And the two affidavits, sorry, if you're on your feet and can help us very quickly.
The two affidavits as we're on the merits.
No, to support the bill. Mr. Clayton was saying there's a bill and there are two affidavits, and you have to look at them together.
I think it was the costs relating to the two affidavits, I think.
The costs relate to two affidavits. Sorry.
All right, thank you. In which case the bill may be sufficient.
And also the board will see that there are quite a lot, this is actually set out in our case, in fact, but in our case we set out that there were a number of objections made about the scale of the costs. And I'm told that the bill of costs is attached to an affidavit, which you will find at page 1700.
Thank you.
And we'll get the references for you of our submissions on the costs. I'll ask my learned tutor to find. It's in their case, actually. It's referred to in a paragraph in our case. Okay, if I could next move, please, to the submissions about whether our complaint that raising $250,000 breached the constitutional right of access to the court. As actually we say at paragraph 14, the point made by my Lord Sales at the outset, is there is the concession at paragraph 14 of the speaking note, and then the analysis adopted by the Court of Appeal, which is in the case of Carey. And I want to briefly look at Carey because, in fact, the Court of Appeal appears to have misdirected itself in relation to what's said in Carey in any event. Now, we can find Carey at 3016. The head note simply sets out the general principles, so I think we can go straight to the judgment. Carey is a case where the appeal was on quantum only. And it arises because there were three separate security for costs applications. If you could turn firstly to page 3019, at letter B, you will see in March 1992 the defendant first applied for security for costs. And that's dealt with more at letter E. The application before came before Mr. Recorder Tackerbury, Queen's Counsel, and he made Tarmac pay $25,000 into court, and $41,000 was the defendant's estimate. The second application is discussed at paragraph H. In June 1992, Mr. Recorder Butcher dismissed the application, there being, in his opinion, no material change of circumstance. If you see that. And then the third application for security, if you turn the page to you won't necessarily turn the page, but 3020. If you go to letter E, you see common ground trial to last 20 days, now 30 days. Defendants consequently laid a third application for security for costs. The bill costs and so on were $115,000 plus VAT, and those were the figures. So the question that arose was the decision on the third security for costs on quantum erroneous? And Lord Justice Peter Gibson sets out certain principles which begin at 3021, letter H. They begin there, but I want to take you to the fifth principle, which appears at 3022. The fifth principle is the court, in considering the amount of security that might be ordered, will bear in mind that it can order any amount up to the full amount claimed by way of security, provided it's more than a nominal account. It doesn't need to order a substantial amount. So, unsurprisingly, the position is that the court has to exercise a discretion when it considers quantum. I then want to turn to page 3024. And look at the errors of law that Lord Justice Peter Gibson found in the case. If you at 3024, between G and H, he asks himself, guiding myself by the principles he's described, I ask whether the official referee did err in law. In my judgment, he did so in the following respects. And I now want to look at a specific finding he makes, which appears on 3026. 4. It appears that the official referee considered only whether a substantial order for security would stifle the claim. He did not consider whether a lesser sum than a substantial sum would stifle the claim, or otherwise be ordered by way of security without preventing the litigation going ahead. Now, in our submission, that is an important error identified by Lord Justice Peter Gibson in this quantum-only security for cost application, because that was not the approach of the Court of Appeal. It never asked itself the question, well, is there a lower figure?
Which it didn't have to, because it concluded that the higher figure wouldn't stifle the claim, or it hadn't been shown that it would.
Well, I'll come to. It concluded that I'll deal with that in a moment, but I'm simply saying that it didn't ask itself.
Well, that was irrelevant on its reasoning, wasn't it? If it had concluded that the higher figure would stifle the claim, then it'd have to go on and consider what lower figure would be appropriate.
I'll deal with that now, if necessary. What they decided was that it was reasonable to infer that there would be backers who would find the money. No reasons given for it. I'm going to demonstrate in it shortly, which is a different point altogether, that there's simply no basis for that being said. None at all. But to return to where I am, what I want to make clear is if that argument, if that holding was flawed, it was nevertheless a question which the Court of Appeal never asked. They never asked itself, was there a lesser sum? What they said...
But they didn't think it was flawed. They thought it was right.
Well, we'll now go to another. They thought that on the basis of the view they took about the backers.
Right. I understand that you will criticise that aspect of their case, but like my lord, I'm at a loss as to see how you're fastening on point 4 in Lord Justice Peter Gibson's judgment as bearing upon the current criticism of the Court of Appeal.
Well, all right. Let's move on to that point. So, parking that point for the moment. I'd like to move to the section beginning with the government's case. And we're told, paragraph 19, that the position is helpfully summarised on Article 6 in the Rowan and Genius case.
I'm so sorry. You are now, is this right?
Paragraph 19 is...
You're not pressing us with paragraphs 15 to 18. We just put a line.
I'm not. Well, I'm not. I take on board the point that you make, or my Lord Legate made, was, well, they had no need to look at what the points made by Peter Gibson because they took a different view about the position over the backers.
Well, can I ask you on paragraph 15 of your speaking note?
Yeah.
You quote paragraph 6 of the judgment, and do you take issue with the correctness of the first sentence they're quoted?
Yep.
As to the legal test?
Yep. And I'm going to do that by reference to the gold trade case. I mean, that's what most of this note on this in this issue deal with. It's what I'll look at gold trail in a bit more detail in a moment.
So you say that's the wrong test they're stated in the Trident, what was stated in Trident?
Well, we would say that is not the Article 6 approach. That's the submission.
So what do you say is the correct test then?
I promise I'll
wait for that. Okay.
Well, can I just... It will be. I'll be within 5 minutes. I'll get to that.
Right. I just want to understand what points are live before us. It sounds as though, although just at the moment you're skipping on to paragraph 19 of your note, you're not actually abandoning points falling within 15 to 18.
No, I'm not abandoning them.
It's just that you're going to come back to them to develop them at some later time.
Yeah.
Right. Okay.
And what I want to do is deal firstly with Roe and what would be definitive or helpful in Article 6.
And I'm so sorry. What's the logic of skipping over your submissions at 15 to 18 at this point?
Well, I think 17 and 18 are dealing with the partial, the paragraph 4 of Curie, which therefore would only arise if the Court of Appeal were wrong in their principal approach.
I wonder if that's true of 18, because that 18 I had rather understood to be making a broader point that there should be a less strict approach to the test for stifling a claim in public interest litigation.
What? No, that's our point is slightly more precise than that. The fact it has a public interest is a relevant factor when exercising discretion on quantum.
Oops. Okay.
That is the point that is being made there.
But I think you also make the point that the Court of Appeal should have considered whether a lower amount was appropriate. And that's a point which is independent of whether or not there was a stifling point. Even if it's right that they held that the claim would not be stifled even at 100,000, therefore it's not going to be stifled at 35,000. Nonetheless, for other reasons, they should have considered whether a smaller award was appropriate.
That was the approach I was endeavouring to set up. I mean, it may be, if it is my call, I apologise, and I'm sorry if I'm not firing on all cylinders, but I'm doing the best I can. What I'd like to do, if I may, is deal with the way in which the Court of Appeal have approached the backers question.
That seems to me the most important.
Yeah, I'll do that in two stages, if I may. The first is I just want to look about how Article 6 fits into the picture. And the first stage is simply to say that the Roe case, which is a case about security for costs for litigation funders, is a case about the backers question. And what I'd like to do, if I may, is deal with the way in which the Court of Appeal have approached the backers question. And I the first stage is simply to say that the Roe case, which is a case about security for costs for litigation funders, is a case about is in a very different context, because it's litigation between private parties in respect of whom both have Article 6 rights. That is not this case. This is a case where only one party has Article 6 or constitutional rights, that is the claimant. The government doesn't have Article 6 rights. And I say that by paragraph 20, subparagraph 3, bottom of page 9. It's because the public authorities can't be victims for the purposes of Article 34 of the European Convention on Human Rights. So our case is basically a classic...
What about the developers? Do you accept that they have Article 6 rights engaged here?
Well, I think the fair answer to that is they potentially may. They potentially may, but that gets into the question of the justification for granting security for them, which is a separate issue involving the so-called Bolton principles. So that's the answer, the fair answer, I guess. But what our case is, and this is really the point I'm making, is that our case, paragraph 20, subparagraph 2, is this is a dispute between a private litigant and the state. It's a classic human rights or constitutional case. And therefore, little assistance will be gleaned from looking about the approach you take when both parties have potentially conflicting rights. Now, I want to move to Gold Trail, which I think...
But I mean, doesn't the legal system generally aim to treat all parties engaged in that system fairly? I mean, you're not saying that the government can be treated unfairly.
No, I'm not saying that. But what I am saying is that isn't... No, I'm not saying that they can be treated unfairly.
All right.
The more important question, to be frank, is the Gold Trail question, which is the proper approach the court should take, is whether a company has to establish on a balance of probabilities that there was no funds available, which comes, I think, or at least stated in Kiri. And that is at the center of the government's submissions. And they say, amongst other things, that it's fatal to this case. And they say that at paragraph 60 of their case. And we would respectfully submit that that just isn't correct in terms of looking at what Gold Trail actually deals with. And we find that at 2974. I think this may be a case that Lady Rose dealt with at an earlier stage.
I remember it well.
I thought we might. This is a case, perhaps you should read the headnote to get a sense of it. Okay. I'll tell them that now. Thank you very much. Can I just return to a point which, to complete something Lord Sales asked, what's all the material on the bill of costs, the government's bill of costs. The other material on that question are our criticisms of the bill of costs, and that is to be found at 1914, 1915. That is in an affidavit, but those are the criticisms made. So those, in all, are the criticisms just to the effect that of the elephant in the room, which is these figures are just way out of line. Now, having read the head note, can I next take you to 2977? At 2977, paragraph 4, the court's been asked to address the principles it's about a condition made in respect of an appeal, but that doesn't, I think, matter for present purposes. In particular, this is line 5, to identify the principles by reference to which it would appraise a respondent's contention that an appellant's financial relationship with a wealthy third party is such as to defeat its complaint that such a condition would stifle its appeal. So in other words, what this case is about is looking to the third party, wealthy backer, owner, and saying what principles should be applied. And it then goes on to say, little dispute between the parties as to the principles the court should apply, but there is a debate about how Lord Justice Patten applied those principles. The next point to note is to turn to page 2979, and you will see that there are findings made to the effect that Mr. Bagana, who's effectively the supporter of the company, is extremely wealthy. And from findings 11A through to 11R, it's clear that he's a man of very considerable wealth who is very intimately involved with the company which is involved in these proceedings. It's pointed out he's extremely wealthy. This is A. And for him, an outlay of £5 million was not a significant outlay. That was what my lady decided at first instance. That he held 3% of the shares and held 81% in a company which owned a further 92% of the shares. That he was paid substantial dividends at C. That for some reason ONAR had guaranteed debts owed to him by another shareholder. J. That with his support, the company was able to continue trading. Were the court able to take his financial position into account, its application to discharge the condition could not succeed. That's quite an important fact to note in the context of what this case takes us. O. To take it into account would not be the same as to oblige the third party to comply with the condition to impose. Then the rest of the paragraph, in the light of these features, the circumstances were exceptional. Owner failed to establish a condition of payment the court would stifle. Then if I could ask you to go to 2981. Beginning at the top of the paragraph, there is no doubt, indeed it is agreed, that if the proposed condition is otherwise appropriate, the objection that it would stifle the claim of the continuation of the appeal is a condition which needs to be established by the appellant, and indeed, although hypothetical, established on the balance of probabilities in respect of for the respondent to establish matters relating to the reality of the appellant's financial situation, of which he knows very little. Now, it's important to differentiate this case with our case, which is very different, because we have raised two concerns. One, that the hypothetical figure sought is far too high, and secondly, that the material which the conclusion the judge reached, by the Court of Appeal reached, that the backers was reason to suppose the backers could provide the money, is completely unexplained, and there was no evidential basis for it whatsoever.
Well, I understand you've got issues with the application of the test, but are you disagreeing that the proposition in paragraph 15 is the applicable test?
I am, to this extent, because as I understand the Goldtrail case, it's actually dealing with a narrower set of circumstances, which is this particular context of a very wealthy owner being asked to cough up for the condition being paid.
That's a general proposition which is stated there, which seems entirely consistent with what's stated in Keary, paragraph.
Well, that's true, but let's, all right.
What do you say the correct test is if it's not that?
I say the correct test is that the correct test is, assuming that it's on the basis there's a constitutional right, is does the figure put at such a level that it, in effect, brings the case to a halt?
Well, yes, you've got to go beyond that because everyone agrees that's the test or something like that. But what is the test for deciding whether an apparently impecunious company can nonetheless rustle up the money from somebody else, either in the Goldtrail case, the wealthy owner of it, or in our case, either the owners of it or people who are also directly affected by the proposed development.
Well,
now, do you say that Goldtrail is the only circumstance? You have to show that the company is owned by a wealthy owner? Are you saying it's for the government to show that the backers could have been asked? Or do you accept what seems to be said in paragraph 15, that it's for the company to show that it's tried and failed to rustle up the money?
Well, the evidence before the court was that the company, the claimant, the appellant, had tried to raise $50,000 and had so far got to $35,000.
We're not asking you about the evidence at the moment, Mr. Clayton. We're just simply seeking to understand what you say the legal test is, and you seem reluctant to explain to us.
Well, there is a point which I want to just come to about when you look at backers. Can I just take you through a little bit more of the judgment?
Why can't you tell us what the legal test is we're applying before we look at the facts to which we apply them?
Because the principles are refined by Lord Neuberger, so I'd quite like to take you to that extension of them. Thank you. I think we were at 15, and I bear in mind what my lords have said. I want to now look, however, at 18. It seems, here we're talking about a controlling shareholding, when in response to the claim of a corporate appellant that a condition would stifle an appeal, the respondent suggests the appellant can raise money from its controlling shareholder. The court needs to be cautious. The shareholder has a distinct legal personality which is always to be respected, save where he has sought to abuse the distinction pressed and pressed. That must remain at the forefront of the analysis. The question should never be, which is the point I wanted to take you to, whether the shareholder can raise the money. The question must always be whether the company can raise the money. That's why I hesitated. Then if we could turn the page, that point is...
notwithstanding that one bears that in mind, which is emphasising the point that it's the company that is the litigant, not the shareholder. What is the test?
Well, we're here dealing... Can you just give me a moment to just confirm something? Is this the company? All right, okay. Well, what I accept is that you look at the company, but you can't say, well, they'll be bailed out by the shareholders, because that's specifically you still have to look at the company. This is a
Sure, but they may or may not be.
yeah.
So what's the test for determining?
Well, I think I want to say this, which I think, with respect, would submit as important. We're here concerned with judicial review and what is said to be a public interest company. And in our submission, context matters. And when assessing whether a claim is to be stifled, one has to be realistic. Another phrase which comes from Goldtrack later on, about what the context is and what in reality the ability is to raise the sums in question. To simply airily conclude, which is effectively what the Court of Appeal does, that it's reasonable to look to the backers to come up with 250,000 in the face of the evidence, which is that they'd raised 35 to get to 50, is hard to understand.
Let me ask you this. Who bears the burden of proof? Question one. Is it the company that claims that it has to show that it would be stifled, or is it the other party? And what is the test? Is it balance of probability, as stated in paragraph 15, or do you say it's something else? I don't yet understand in what you say. If the test is not, as stated in paragraph 15 of this judgment, that it's for the company to show on the balance of probabilities that the claim would be stifled, then if you say it's not that, then I want to write down what is your proposition.
Can I just have a moment to reflect on it? Well, subject to the point I made that you have to continue looking at the company rather than the backers, and subject to also the context, which is that this is a judicial review case brought on allegedly what is alleged to be public interest grounds in an environmental context. You will have to be satisfied that the claimant can meet the imposition. But that means it carries with it a very important corollary, which is that there has to be a degree of realism from the court when it fixes quantum.
I still haven't understood, I'm sorry, Mr. Clayton, whether you're accepting that the test is in paragraph 15, although you want to emphasise certain matters of context, etc., or whether you're not accepting it, and you're saying that the burden of proof is different and that the test is other than, or the test is other than the balance of probabilities.
I'm sorry if I've been unclear. I am accepting the principle.
Right.
What I was saying was this, however, that one has to focus on the company rather than the so-called backers, which is specifically what Lord Neuberger says, and that one has to be mindful of the context, it being a public interest claim, because it's important to make this point. If one applies this in the way this has done in this case, it would be the end of public interest litigation. And that's why I add the corollary that there has to be some sensible and realistic figure rather than $250,000 for a 2-day case. I mean, that's simply way out of line. And if I failed to make that point earlier, I apologize. So really what it comes to, which I think is why I say why I suggested the Keary point in the way my Lady Rose suggested, is there has to be some care taken about how to pitch quantum in the scale from substantial, from the figure house to substantial.
But I mean, in a sense, that's always going to be the case. I mean, the court's always got to be careful
Yeah.
so the claim isn't stifled. I'm not sure that just saying you've got to be careful helps us very much.
Well, this case arises on a particular set of facts. It's the facts of this case which make, in our submission, this order, the scale of this order, so difficult. I mean, realistically, say talk of a case in England, say, 2-day judicial review case. What's that going to cost? 30 or 40,000 pounds, something like that. Well, no one can complain if they got a security for costs at an early stage, say, of £10,000.
Well, in the Hackney case, or Haringey Hackney, I think, it was 60,000.
Yeah, that again, cases differ. But
Well, that's the point, isn't it? And jurisdictions differ.
they do. But judicial review cases, in general terms, are not wildly expensive, partly because they're short.
It all depends on the level of legal fees in the relevant jurisdiction.
Well, that's why you need to look at the draft bill of costs and the points.
Well, that's, again, the difficulty. I'm afraid I have no knowledge at all of the level of costs in the Bahamas.
Well, let me put it this way. The suggestion that costs of $350,000, which was the claim made, for a 2-day case.
Well, I understand the general point you're making, but I come back to the government's. But can I just come back to this public interest angle to this?
Yeah.
Is the relevance this, that if you're dealing with a public interest case, judicial review, that's something to take into account in determining whether it's likely that the company that is the claimant will be able to raise funds from members of the organisation or others? Is that really what it comes to?
Yes, it does. And I think, if I may say so, the real difficulty for the claimants, the appellants in this case, is not so much that recourse should be made to backers, but that the scale of what's been suggested is completely out of reach.
Well, I can see there are backers and backers. I can see that there might be a case where the claim was being brought to protect some particularly vulnerable animal, and that particular charity may have attracted the attention of celebrities who are prepared to donate money to it. But one wouldn't then say, well, go to those celebrities and get them to pay money if their actions in supporting this charity are purely philanthropic, because that's their choice to be philanthropic to these particular animals. But I think what's said here is that the backers here are not of that kind. Their interest in this is not simply philanthropic and therefore not to be taken advantage of, but that they have a real interest in being landowners who will be affected by this. I can see that a public interest argument would be relevant to say, even though a charity has wealthy backers, they should not be called upon always to stump up for security for costs or to pay the judgment into court. But I don't think that's what is the situation here. That's not what the government or the court was saying. It was something a bit more than that, wasn't it?
No, well, I'm afraid I accept that context, that not only in terms of the judicial review case itself being a particular area which has its own, which has to be borne in mind, but the nature of the judicial review challenge also would be a relevant factor to bear in mind. The point made by Lady Rose, if it's characterised as philanthropic, that may take one approach. And if it's sort of, say, something else, for some financial interest, that might be different. But with respect, our principal concern in this case is really, it really comes down to the size of the award made. Yeah, I'm reminded. The case is, the evidence about the 35,000 is that it's come from small donations. I mean, it's not the case that we're dealing with a few people who've summed up a lot of money.
But the point made against you is that there's no evidence that you asked anybody for the money and that they refused. And I don't want you to give evidence from the bar as to what happened, but the point is whether you really are just reliant on selling bumper stickers and T-shirts, or whether there are wealthy people also interested in the relief that you're seeking, who, if you had asked them, might have given you the money. Isn't that what's the point?
I understand my lady's point, and the best answer I can give you is that the level of which security has been ordered is so high as to discourage anyone from coming forward, and indeed to discourage anyone from taking environmental cases because of the risks involved with orders, which basically means the case ends before it's ever heard. That's the problem. Yeah. I mean, whilst I won't give evidence for the bar, obviously, the proof of the pudding is in the eating. I mean, this case has made no progress ever since the order has been made.
Well, that's because you're still contesting the order.
Well, that may be a rather ungenerous.
Why was the Court of Appeal not entitled to reach the conclusion that it did? That's what we need to hear, I think.
Well, I'm not going to go over ground I've already gone over, but I have, what I've done in summary is this. I have gone through the complexities of the case. I've looked at the evidence that was before the court. I've invited you to look at the criticisms which were made of the bill of costs. None of those issues are canvassed.
No, but I'm just referring to the point you're on now, which is that they drew the inference it was reasonable to infer that if requests were made, money could be provided by funders, and where did they go wrong in?
Well, the difficulty is that we don't understand how they could draw. They don't explain why the inference comes to be drawn. There is a huge difference with respect, and it's a feature of this case, that there is a difference between giving reasons to explaining an adverse finding and simply asserting an adverse finding.
Well, can we just look, before we get on to the backer's point, we go to the Court of Appeal judgment.
Sorry.
Paragraph 50 sets out the Curie principle which you've accepted.
Yeah. Sorry, can I just find it? No, sorry, can you just give me a moment to get it?
It's page 801.
Okay, just give me a sec. Yep.
So paragraph 50 is the principle that you bear the burden of proof on the balance of probabilities which you've accepted. Paragraph 49, you say, on your evidence, you haven't discharged that burden. Now, how is that an error of law?
Well, if that was the error of law, we would say, is fixing the figure. If you're satisfied that the figure that was fixed was entirely is one which survives any legal challenge in this court, then I would accept that it would follow that the point you make about paragraph 50. In other words, if the figure is right, then the burden is on us to satisfy it. We did, however, put material before the court. That material was there. And
they say it didn't show stifling of the claim even at the figures being put forward.
But that is what is so odd, because there was no evidence that anyone had any money.
That's the point. There was no evidence, and it's your job to produce the evidence. What happened in the Gold Trail case was that there was no evidence from Mr. Bagana what there was evidence from Honour saying that Mr. Bagana had said he wasn't going to put the money in. And they relied on that. And the Supreme Court sent it back to Lord Justice Patten, who basically said, well, let's see whether he does or doesn't, and refused to lift the condition. I don't remember what actually then transpired. But it was very clear, as Lord Justice Patten said when it went back to him, that the burden was fairly and squarely on Honour to satisfy the court that the condition would stifle the appeal. And Mr. Garner simply saying he wouldn't put up the money wasn't enough. Now here we don't even have evidence as to whether people have been asked and said that they would or wouldn't put up the money. But again, I'm not asking you to give evidence. I'm saying that your protestations that the Court of Appeal had no evidence on which to make this conclusion is not helpful if you're the ones who ought to have put in evidence to satisfy them.
Can I take you to what the evidence that there was before the Court of Appeal? The only evidence, in fact, it comes from the Supreme Court. It's page 1896. Yes, it's from an affidavit. It's paragraph 20.
And whose affidavit is this, please?
It's the second affidavit of Mr. Crispin Blunt. Crispin Hall. Sorry, Crispin Hall.
So this is the evidence that is referred to, is it, at paragraph 49 of the Court of Appeal's judgment? Right.
That's right.
What's the page again?
1896.
1896, yeah.
Thank you very much.
I accept that is the evidence. The point being made to me is that this certainly, obviously all cases differ factually, but this is not a case with substantial backers. That wasn't the evidence.
Well, we don't know whether it is or isn't.
Well, one can infer something from the fact that they're making...
Is it?
It says there's a large number of generally anonymous individuals who are donating sums mostly under $500.
Right, but I mean, the paragraph 19, Mr. Hall is positively asserting that the company will be able to pay the respondent's costs if the respondents are successful at trial.
Yeah.
So that's the opposite of stifling. That's saying, yep, we'll be able to pay.
Sorry, I'm going to call them across. Can I just...
All right.
Sorry. Thank you, sorry. Well, two slightly different answers from two different people. One is that the essential problem is quantum, which is the starting point of all of it, the size of the order made.
But there's nothing here to suggest there's a problem with the quantum at any rate of the government's application for security.
Well, I'm afraid I'm going to suggest to you with respect, my Lord, that when you come to look at the bills of costs and so on, you will be surprised. Just if you look at just how it's expressed.
That, if I may say so, seems to me to be a somewhat different issue. It may be that you've got points to say that the quantum ordered by the courts in this case was too great. We haven't come on to that yet, as far as I'm aware. We're on the question whether, at the level at which security was ordered, would the claim be stifled? And this is saying, no, it won't be, and this is your own evidence.
Well, might have expected to find something in here saying if you make an order for the amount they've asked for, we won't be able to pursue the claim.
Well, if you go, that's, I've been taken to page 1901, same affidavit. It's paragraphs under the title, the late application for securities oppressive and will stifle. We have, can I ask you to read 37, 38, 39. So that's, it's certainly not accepted that it won't stifle. Different point from the one I'm being pressed on, I accept, but I don't accept for a minute that we could.
But
That's
even,
a time point, though, isn't it? And that's, in a sense, acknowledging that we can do it. But
even here, where,
Apart from the exclamation marks after the 350,000, I don't think there's...
even here, he's not saying it will stifle. The point being made, as so far as I can digest it here, is that the court ought to take a dim view of the applications because there is an intention to stifle, even though it won't.
Well, I see my Lord's point about paragraph 37, but I thought I had dealt with at an earlier stage the concerns about the level of quantum. That's why I looked at the evidence. That was why.
You've explained why you say the level was too high. What you've not explained is what evidence there is to show that if an order for that amount was made, it would stifle the claim.
Well,
You say it's to be inferred, do you, from the fact that the description of the efforts made to raise money and that they hadn't met their 50,000 target. That's the high point of the evidence?
well, one could. That high point is that is the evidence. I can't go beyond what the evidence is before the court. I'm not.
No.
Sorry. Well, yeah, the evidence also demonstrates the rate at which money could be obtained. But I do accept the point made to me that is there positive evidence that they asked people that whether they could get to 350, 250, so sorry. There isn't any. And that's why it may be that the point which is of most concern in this case, and this is not just unique to this case, this is a feature of environmental litigation in the Bahamas, is that security orders for security are so high. Now, I accept the point made by Lord Richards that it's important to differentiate between the position of the government, who on any view is entitled to seek security, and the developers. But I'm bound to accept that, and I obviously can't fashion more out of the case than there's the material before the court, and I'm not seeking to try to do that.
Mr. Clayton, just going back to paragraphs 50 and 51 in the judgment of the Court of Appeal in this case.
Yes.
And took you. In paragraph, sorry, it's at page 801 in the electronic bundle.
Right, okay, thank you. Yep.
Paragraph 50, the court, or the President, cites apparently from Kiri Development, in inverted commas, but I can't find that statement in Kiri Development. And I'm not sure it's an accurate statement either of Kiri Development or of Gold Trail, because the test, as is made extremely clear in Gold Trail by the Supreme Court, is not whether Abaco can put up funds, but whether the company can raise funds.
Yes, precisely.
But I'm not absolutely sure that in this passage the Court of Appeal was applying the right test and may indeed have been misquoting Kiri, but that's not necessarily a a knight on a white charger as far as you're concerned, because it is equally clear, as my lords have said, from my lady too, from Gold Trail, that the onus lies on your client to demonstrate that it probably can't raise funds from third parties.
Well, can I...
It may be you have an argument that the Court of Appeal here has applied slightly the wrong test. It slightly depends how you read the apparent quote from Kiri Developments. But applying the Gold Trail test, well, what I would suggest actually is the Kiri Development test and the Gold Trail test, still exposes you to the fact that you didn't put much, if any, evidence before the court as to the inability of your client company to raise funds from backers, members, interested members of the public, neighbouring landowners, and so on.
With respect, I accept the points you make. I mean, certainly, I'm afraid I haven't identified where in Kiri that...
Well, actually, I don't think it does come from Kiri. I think it comes from what was said by the High Court judge in the Hackney case. And I think that he may have slightly misstated the correct Kiri and Gold Trail test.
But accepting the burden of the points made against me, accepting that, even so, the point which I was trying to make earlier about Gold Trail is important to remember. It's the company and not the third party.
Absolutely.
Where the burden
Absolutely. But that's where your evidence is somewhat lacking.
Well, that may be so.
I mean, we know it's a slightly opaque organisation, your client, I think it's fair to say, in light of the lack of evidence. But I think we're told somewhere that it's got 2 issued shares, with the registers holders of which are, I think, partners in a firm of solicitors in the Bahamas, who hold them on trust, I think it said, for 75 beneficiaries. But we don't know who those 75 beneficiaries are, and we don't know what their interest might be in seeing that this JR claim can be pursued.
Yeah.
And they may be people with a close personal and proprietary interest, a financial interest, or at any rate a personal proprietary interest in resisting the development.
Yes.
We just don't know.
We don't know. What I really want to say is this, is that to sort of close down this area of the discussion, is I accept that the focus has to be on the company. I accept that the evidence which is before you is the evidence that we've all been looking at. And I think which emerges out of that, which is of most import to the appeal, is actually the scale of quantum itself. If you're satisfied that the scale of quantum was legally unimpeachable, then Gold Trail would make the position very difficult from the appellant's point of view.
So when the application for security came on for hearing, did both the government and the developers make clear the security they were seeking?
Well, it was slightly more complicated. What happened was the government said they wanted 150 and ultimately got 100. That was they said 150 shortly before.
When did they drop those from 350,000?
That was the developers. Yeah, that was the developers.
That was the total of both, yes.
Yeah.
Well, from the 350 with the exclamation marks, I take it that Mr. Hall was aware of the amount being sought.
I'm told it was 350 for the developers and 150 for the government. That was the claims.
Right.
So, I mean, evidence could have been adduced, addressed to the inability to raise from backers or others those amounts.
Well, excuse me. Well, this is our considered position, is that having regard to the actual figure that was ordered, we would say that on the balance of probabilities, it should have been inferred from the evidence put in that the backers would not be able to raise the sum on that scale. Sorry, forgive me, the company. And that's why, given the way the debate has moved in the last while, I think that's why the debate, our submissions about the size of the report are in the end the most important. My Lords, that, and no doubt entirely my own fault, has taken up quite a lot of time. And in the light of that, what I'm going to do in relation to the corner house points is simply rely on the submissions in writing and move.
Well, just on that, can you explain to us how it fits into the scheme of your submissions, at least?
The way it fits in is, in the event this appeal were allowed, and the case would be remitted to the Supreme Court to approach the question of security for costs afresh. And in that event,
You're asking for another hearing on security for costs, if you succeed.
Well, what else could I get?
Well,
You could ask us to,
Yeah.
if you succeeded in your submissions,
Yeah.
we would say the courts below have had a discretion which they misapplied. That discretion is then at large, and then there would be a question whether we exercise the discretion ourselves or whether it's remitted.
Well, all right, I understand that. Well, the only so the strict answer is, how, in terms of the answer of how corner house fits in, it is only in the event that it was felt appropriate to remit it back to the Supreme Court that corner house becomes relevant, I think. Because I'm not sure you have all the material that you'd have needed for the corner house here.
And on the prior question, whether you would, if you succeed in your appeal, invite us to exercise the discretion or to remit it to the Supreme Court, or indeed the Court of Appeal, what is your submission as to what we should do?
Can I take instructions?
Certainly.
So that's what I think our preferred course would be for your lordships to, including obviously my lady, to make the determination of what...
So not remit, you say we should just exercise the discretion ourselves if
Yeah.
we succeed in the appeal.
Yeah.
So if we acceded to that submission, the corner house point just falls away.
Yes, it does.
Right, okay.
Yeah. So that would fall away. So that's yet another reason why I won't make oral submissions on that. Can I move then to the Bolton submissions?
And the corner house point is
Oh, sorry,
the point about a protective costs order.
that's correct. And can I also say that I obviously maintain in relation to the constitutional stifling point our paper submissions. But I'm just not going to make any more oral submissions about them.
I'm so sorry. I didn't hear how you introduced the what point.
I'm sorry. I think I'm losing my voice. That in relation to the stifling constitutional point, we have no further oral submissions to make. We do make, however, our written submissions, which you have both in the case and in the speaking note. And in relation to that, you have the concession, which my Lord Sales pointed out at the outset, that if the figure does stifle, that would amount to a breach of Article 20, sub-bracket 8 of the Constitution. Oh, sorry, that's true. It might be that if your lordships would did consider the case, you might look at whether a protective costs order was appropriate on the material you had. But that the difficulty would be with that it wasn't something that the lower courts has expressed a view on. So various suggestions are being made to me as I'm going through this.
Right, and nor have you developed a submission before us.
No.
So it would be very difficult for us to do anything.
Yeah, no, I think that's right.
Very well.
Sorry.
You haven't even got an application, you've never made one for protective costs orders, and I don't really know how you can start now.
So, sorry, if I could, yeah, just give me a moment. So the point being made to me is slightly differently, which is that if we satisfied the public interest requirements to obtain a protective costs order, that might be a relevant matter for you to consider as part of your view on quantum. That's all.
How would that work? You've already.
I haven't abandoned the submission. I'm simply relying on them on writing. I think I just really want to move on. To be honest, can I come back to this after
All right.
I'm certainly not benefiting from a shortage of advice, but I'm concerned about time.
Yes. All right.
Now I want to turn to Bolton. Sorry, we pick it up from the note, page 20. Well, yeah. It starts at page 19. The submissions start at page 20. And I'd like to look quickly at it's a very short case anyways, the Bolton case, which is a 2898. If you have it, it's probably not necessary to read head notes because the judgment's so short of Lord Lloyd. If you could turn to page 2900, what is the proper approach? As in all cases, the fundamental rule is no rules. Costs are always at the discretion of the court, and a practice, however widespread or long-standing, shouldn't be allowed to harden into rule. But these following propositions may be supported. Want to draw your attention to the second principle at H. The developer will not normally be required to assist costs unless he's entitled to be heard. It's an issue not covered by counsel for the representation. The mere fact that he is a developer will not of itself justify a second set of costs. That, with respect, is important in relation to the application for security. And then the views expressed by Lord Lloyd on what has to be shown to get an order for special, that there's the case of special features which warrant an order of costs. And they have started 2901, beginning with B, the case has special features. First, it involved difficult questions of principle arising out of the change of policy, and the developers were entitled to take a view on the facts of the case that they had sufficiently independent interests requiring protection to justify separate representation. Well, that's not this case. The scale of development and its importance to developers was of exceptional size and weight. That's not this case. And that opposition came not from the local authority, but from 8 neighbouring authorities supported financially by a consortium of commercial interests. So the long and the short of it is that special features expressly referred to in Bolton don't cover this case at all. Then dealing briefly, and I don't need to take you to the authorities for this, the Bolton principles have been adopted in the Bahamas, both in the commercial case of Weisstisch, and then in Bimini Blue, which was an appeal on quantum only. That's subset.
So they say that none of those are made out here, but I think the developers say, and this was partly why I think I was asking you about what the position is with the permits. But if it's the case that none of the permits has in fact yet been issued, I think they would say that the first of these special features is made out in that this, like the Bolton case, is not a case where the government and the developer are both trying to uphold a decision that has already been made, but that as no decision has yet been made, the decision maker, the 8 decision makers in your case, have to, quote, remain aloof from the parties in the same way as the Secretary of State did here.
Well,
so what's your answer to that?
my answer to that is, which we'll look at in a second, is what actually developers said. They didn't say that. Like they said nothing other than the fact that what they say is we're going to be financially affected by the result, which is exactly what every planning in every planning case is the position with a developer. They're always adversely affected by the result. The point is that they are not, this is a public law dispute. They are interested parties. And in reality, and in practice, developers often appear in planning cases that very seldom get awards of costs. And also, I'm going to make this point now, but I'm going to develop it later. In any event, to make a decision that they have a potential, that they will get their costs at this stage of the proceedings, in our respectful submission, is premature, because developers need to wait to see what the trial judge does, who hears the trial, hears the submissions, and decides what the appropriate determinations in the case is. And this is an entirely speculative exercise to say, well, it has adverse consequences for us, and therefore we should be entitled to make an application for security.
Well, you've got the point to start with, that they put in no evidence that's separate, and on the face of it, not apparent what separate submissions they might have to make that aren't going to be made by the government, or what different case they might want to advance on consultation. Unless they can show that something's different from what the government's going to say, which is we've done enough consultation.
Well,
they don't need to be there. Well, they can be there, but they've got no need to incur costs.
And if I could add another point to the one my Lord Legate just made, is they go through the 8 grounds of appeal in the court, their submissions to the Court of Appeal, which are no different in substance to the government's ones. They just simply make the same points a second time. What I wanted to do was to say that the Bolton point was raised on numerous occasions.
Well, does that really matter if the question is what the correct principle to apply is, and if the Court of Appeal haven't applied the correct principle, then really steps us to the cost of this appeal, perhaps?
Okay, well, I'm not going to. I don't think I'm not going to.
Well, it would assist me at least to have the references that you rely on.
Yeah, well, I have given them. That's 'cause, let me just. What I wanted to take you to, as well, about separate interests, however, was what appears in the Encyclopedia of Planning Law, because that is probably the most comprehensive treatment of, and it's the sort of planning Bible in effect.
So that page 4064.
4064, I think that's right. Yeah, sorry, you'll pick it up. It starts at 4064, and if you just turn that up speedily, you'll see that it refers to Bolton, sets out the Bolton principles, and then refers to a few other cases which are different in nature than this one, but where the case is withdrawn at the last moment. That's the decorum case on 4065, where allegations of serious impropriety are made without justification or substance, which the developers clearly needed to refute. That's a very unusual kind of case. And then a decision by Mr. Justice Dyson then was where the developers made an allegation of fraud. And then turning to 4066, a very specific issue which applies to interim development orders, which I won't trouble you with. The Bromley case, where the third parties were, if the council succeeded, the interested parties, which were the residents, would lose their home, and it was unjust that they shouldn't be able to make representations on that.
Are these cases all just awards of costs after the proceedings?
These are cases where separate orders have been made in respect.
Right, but they're not security for costs.
No.
Yeah.
I mean, the whole question of security for costs for developers is a new development. It's very specific to the Bahamas. It's also worth saying that there's no authority that's been advanced by the developers that supports it. The Bimini Blue case was an appeal on quantum only, albeit it does award on a quantum basis. But there's no reasoned judgment that we have to put before my lords and lady, which indicate that security for cost applications can be made by developers. If I could next take you to page 21. Page 21, paragraphs 49 through to 52 are the cross-references Lord Sales asked for about the appropriate. This is when they were discussed below. Of particularly striking is the discussion between the Appellant's counsel and Justice of Appeal Barnett, which is paragraph 52. It's perfectly obvious that everyone's talking about Bolton.
Sorry, which page? I thought you said 21.
Page 21.
21 of the bundle?
No, speaking. No.
Oh, sorry, your speaking note. I'm sorry.
Paragraph 52 of the speaking note.
So it's my speaking note. Sorry, I didn't say that. Page 50 to 52. Paragraph, sorry.
And this is addressing the point whether you had raised the Bolton principles
Yeah.
at an earlier stage.
Yeah. And the plain fact is that it was argued before. And I give the references. I don't think I see the need to make
Well, I did actually have a quick look at those, and I thought the debate was not about Bolton, but about a more general point, whether a party that is given leave to intervene in proceedings can, in principle, apply for security for its costs. So if there's reference to Bolton...
Let me be clear, and I'm sorry if I haven't been. There's no specific reference to Bolton in any of the examples I gave. They don't say, I'm saying Bolton.
Bolton wasn't cited.
Bolton wasn't cited, but what the principle involved is the Bolton principle, which is these are interested parties, that they don't have a dispute or lease alive in this case because they're directly affected by its outcome, but they're not defendants in a public law case. There are no challenges being made against them, and therefore they ought not to be a defendant for those purposes.
And that, I mean, there must be an exception to that where, as sometimes happens, the actual respondent to the judicial review claim, if it's, for example, a tribunal or a magistrate's court or something, plays no part in defending the proceedings, and then the whole burden of arguing the case is on the interested party.
That's true.
That's not this case.
No, it's not.
The government is taking an active part.
Yeah, and what's more, in that sort of case, no one asks for costs anyway. I think it's pretty rare for... The tribunal certainly doesn't, there's law on that, it can't be awarded costs, but I don't actually think the interested party, if it succeeds, gets ordered for costs in its favour in that situation either. So dealing with my Lord's point, I accept that they're dealing in the debate with Mr. Smith, with Justice of Appeal Barnett, dealing with a broader point, but it comes to the same thing, which is there is whether it's appropriate for someone who is an intervener to get an order for costs.
Well, is it your contention that it's never appropriate, or just that it isn't appropriate? There's no ground for making such an order in this case because there's nothing to suggest that they have a separate interest which is likely to result in a separate award of costs?
My answer is in this two separate answers. One is that in this case, plainly not, because there was never a separate interest. In any event, I submit that in principle, it's wrong for security for costs to be granted to developers because until you have the submissions at trial are argued out and the judge has heard all the submissions, it is only at that stage that you can make a conclusion, a proper conclusion is being reached about whether there's a separate interest or not. It's premature for someone to assert they have a separate interest before the trials actually takes place. And
I don't see why that should be so. You know what the material is for the trial before it takes place.
Well,
surely if you had a case in which the developers have put in a lot of evidence and it was apparent that they perhaps had a conflict of interest between them and the local authority,
or they're accused of bad faith in cases that were...
Perhaps I've been diverted by the way in which the separate interest point has been advanced in this case. Certainly in this case, we say there is no special interest. I am prepared to concede that if there is cogent and powerful evidence of a separate interest at an earlier stage, that might warrant the granting of a security for costs application.
So in principle can be awarded, but you say shouldn't have been in this case.
Yeah, and I would also add to that the circumstances they could be ordered would be very rare. Simply reflecting the reality of planning cases, which is that orders of costs made in favour of developers after trial are very rare. Very rare. What's striking about the encyclopedia discussion is how few cases they discuss. It's really the dog that didn't bark submission. And to develop that point slightly more, if you could turn to page 22 of the note. Can I just, at page 56, I give, paragraph 56 sets out the evidence that was before the court. Can I add to that, to the bundle, page 2125, which is the evidence of the joinder from Ms. Brown?
Sorry, is the evidence of
Ms. Brown on the joinder application, that appears behind their case. Yes, behind their case, which was put in because it was omitted from the original record. So it's page 2125.
And what do you say we get from the joinder affidavit of Karen Brown?
Well, I simply say it doesn't. It's either advance any special interest. The thrust of the submissions made, and I'll just summarize them in this way, is that we are going to be financially worse off if this claim succeeds, and therefore we should get security for costs, which is the position in every planning case. And the next point I want to make before turning on the point of detail is the one at paragraph 60 of the speaking note about the wide-ranging implications of the suggestion that developers can get security for costs, will obviously have wide-ranging implications in other countries subject to this board's jurisdiction, and indeed, as suggested by Lord Neuberger and Willis and Joyce number 2, some implications for the United Kingdom too. Can I make an additional point, which it does not appear in the note, and it's worth emphasizing, which is that the costs regime in the Bahamas, which is, you will have got this behind the speaking note, is Section 30 of the Supreme Court Act. And it is in substance the same as Section 51 of our Senior Courts Act. It says basically costs are discretionary. It's the sort of point Lord Lloyd has been making in Bolton.
There are no rules.
No, but there's sort of principles. Then just dealing very quickly, if I may, with the so-called special interests advanced in this case. The first is that leading counsel made comments about the developer's involvement to a reporter in the Tribune. That's paragraph 62 of the speaking note. And we would submit that newspaper reports purporting to quote counsel cannot entitle a defendant to seek security. Make a second point, which is not in the note, is that in any event on the developer's case, it's not causative of the application to make the securities application, because they say in their submissions that they were going to do that in any case on the same day, so it wasn't causative either.
I'm not sure whether it's causative or not matters, because the question is whether there is a sufficient additional interest to justify.
Well, I think that's what perhaps the causative is the wrong way of putting it. But since they were going to do it anyways, and we're in the process of preparing it, it's after the event. That's what they say. They're saying, well, this was quoted the day we were going to do it. Well, they were going to do it anyways.
Yeah, well, in principle, it might have given them a good reason, which they didn't have previously, but I see the point.
Okay. The second reason advanced, and something's gone slightly wrong with the English, is I need to add some words to paragraph 64. The defendant alleges bad faith is alleged against them by the appellant. So by the developers, because they broke promises to provide local residents with an EIA by not consulting properly. Well, with respect, there is no complaint of bad faith against these developers. The complaint is drafted in much more mundane terms. It's just failure to consult properly, breach of legitimate expectations. And then it said that the relief is broad. And this is quite important in terms of the prematurity point I was making earlier. It is unlikely, so I'm quoting at paragraph 66, it is unlikely that the interests and developers of the 9 public respondents will always coincide. So this is a pretty kind of an idea of anticipatory problems ahead justify making an application for security for costs. That is, with respect, a striking submission. And if you turn the page, please, to 24. Subparagraph 3, one can readily see why there is no guarantee that the developer's interests will be identical. It's again quoted from their submissions, their case, and they may well take different approaches on claimed relief and proposed involvement of the appellant. That's why we say the whole application for security costs is putting the cart before the horse. That's why it's better to wait to see, which is another reason why I have submitted earlier that if it is in principle available to make such a security, it has to be strong and cogent evidence. Yeah, and of course they have put no evidence in for trial, as we know. And then lastly, dealing with 67, what is the proper scope of consultation? Well, the answer to that, there's no question about that. That is the Mosley case and gunning principles, which we've already briefly looked at.
They were, I think that they were at the meetings, weren't they? Representatives from them, from the developers, were at the September meeting, I think. But even so, you would say they've not put any evidence in different from the evidence from the government as to what took place at those meetings.
Exactly. And can I, just before the short adjournment, just very quickly take you through to the annex, which is appended to the back of the speaking note. And basically, this is to deal with the table, which appears in the leave application. It's a table which sets out the basis for the required permit and the relevant decision maker in each case. And that's what we explained at paragraph 1. Then we set out the chronology at paragraph 3, which I don't need to trouble you with. And then turning to the page, the next page, 26, on the internal numbering. Letters before action were sent out, paragraph 7, to everyone. Then turning the next page, paragraph 9, no answers were ever received. That's in Pitcairn's affidavit, 1395. 10, further letters were sent in February 2016. And then 11, no responses were received to any of those letters either. And at 12, it's pointed out that the appellant wrote to the respondent twice prior to issuing proceedings. The respondents had the opportunity to set out any basis on which permits were not necessary but chose not to. And then turning to the last page, 28, Whilst it might be possible to join only the relevant ministers, this is the procedural problems which I've already adverted to, the debates which can happen in the Caribbean about misjoinder, non-joinder, and so on. So that I put that in so you understand why the table appears in the form that it does. And then actually, if you just go behind those documents, you'll see about probably 4 or 5 pages back, you'll find section 30. Let me just take you to it. It's about 4 pages back, if you get to that. This is from the Supreme Court Act of the Bahamas. If you have section 30, you'll see.
Well, we don't. Can you give us the page number?
Well, it's appended to the material that you sent.
Oh, I see. Sorry, it's appended to the appendix.
It's after the appendix.
Okay.
There's then the schedule. If you get about 5 pages.
Yes, I have it. Thank you.
Okay, 30 says, subject to this, costs of an incidental proceedings, etc., shall be in the discretion of the court. And we would say, and we put behind it section 51, that it's not materially different.
What's the date of this act?
But this is the act as it is in force now in Bahamas.
Right.
Can you do that? We'll come back to you about that.
And what is the title of the act, just so we can...
It's called the Supreme Court. It's called the Supreme Court Act, Chapter 53.
All right, thank you.
I get that from the title of the index.
Well, that's certainly the title of the chapter, but is that the title of the whole act?
Well, when I found it, I found it as a Supreme Court Act on the site, so that is the name of it. It may not be obvious from what it says, but my point is it's very close to Section 51, brackets 1 of our Senior Courts Act.
So, Mr. Clayton, would that be a convenient moment? I think you've got another 30 minutes.
Yes.
So you'll need to be reasonably efficient and economical with your time this afternoon to stick within that 30-minute limit.
I appreciate that. Thank you.
Thank you very much. We'll rise 2 o'clock.